Dr. Bashai talked about the revenge of humanities and social sciences. I'm going to meet her history and lit and raise her European cultural studies. So and we have a number of HSS people here, so STM includes HSS. All right, thank you all for coming. As we know, publishing, more than a lot of other industries, exists at the sufferance of governments and regulation. In the best cases, governments guarantee our rights to speech, and that allows us to publish. And also, in the best cases, governments maintain rules and regulations such as copyright, which enable us to get compensated for our output freely. In an AI world, we're met with a chorus of free riders who claim, this time it's different. Copyright's not fit for purpose, and therefore we either need to change the rules of copyright or simply ignore them. Technology changes at a rapid pace, but these arguments that we're hearing that this time is different and copyright's not fit for purpose, these go back historically, keeping up with the HSS theme, as far as I know, at least to the 19th century, when we have big tech now. Back then they had big piano, and big piano did not want to have to pay copyright fees for piano player roles. So, late 19th century, this time is different. Then we had recorded music, then we had radio, then we had satellite transmission, then we had VCR, getting closer to our industry. We had photocopying. We were founded at CCC because of the photocopy. We've had email, we've had internet, and every time a group of free riders, whichever that group is, says this time is different, we don't need to apply these rules anymore. Today we're here to talk about AI. We have 4 international experts. We're going to be taking a fairly global approach. We're going to begin with Peter Schoppert, the director of NUS Press. He's going to talk about Singapore and Japan primarily in his opening remarks. For those who don't follow this as closely as some of us, Singapore law is absolutely the worst. We can debate where every other country falls in the spectrum, but we cannot debate Singapore. Following Peter is going to be Elizabeth Krosick. She runs EU government relations for RELX. She's obviously going to be talking about the EU and the AI Act. We're going to also get back to that certainly in the Q&A, especially because it's a very big deal. Then we're going to have Katrina, who's the Deputy CEO and General Counsel of the UK Publishers Association. Not shockingly, she's going to be talking about UK law primarily. And then Jessica Sanger, who is not only with the Borsenverein, so the German Publishing Association, but for this talk, at least for her initial remarks, she's focusing as the head of the Copyright Committee for the International Publishers Association. She's going to be talking about some developments in Africa, some developments in Australia and in Asia. At the end of this, we're going to do a little Q&A. I'll do a tiny bit of moderated questions, but I really want questions to come from the floor. If you don't have a lot of questions, which would surprise me, I have plenty of questions, but I kind of want to let you guys ask what you want to hear as opposed to me just asking what I want to hear, which is fun too. So with that, I'm going to hand this over to Peter. Everyone's going to speak for about 5 minutes. I'm going to time them and be kind of mean about it if they go over, because that's just the way I roll when I do this. But I really want to make sure there's enough time for questions after. So thank you very much.
Thanks very much, Roy. Thanks for the great intro and setup. Speaking from the absolute worst case, according to our introducer. Well, Singapore started an amendment process for its copyright law in 2016 and 2017. And that was just at the time that they were starting their national AI strategy. Remember the days of old AI, which was supervised learning on very carefully controlled and cultivated and clean data sets. and where TDM was extracting and caring for and cultivating data that you were pulling out of texts and using to do supervised learning. And that's the context that we started in. And that was also the time when big tech companies were beginning to push for a TDM exception. My colleagues will know much more about this than I, since they've been professionals in this game for some time, but this is what I heard from the Business Software Alliance. We started our campaign in Asia in 2017. And so that was the context in which Singapore law was made. And not just Singapore law, right? Digital Single Market Directive, Japan's Copyright Act. There was a lot of activity around this time. And I guess the fact that that situation of training, supervised learning over very cultivated data sets does not match the situation we face ourselves, that we are facing now, where we're looking at self-supervised learning on huge masses of bodies of work, which does not require, cannot enable that sort of careful care over data sets. We're all in that situation. And that is really why the mismatch is really why exceptions are just a very bad way to make copyright law, in my opinion. Anyway, Singapore decided when it worked on its law that it would, right off the bat, they decided not to keep the distinction between commercial and non-commercial uses. They felt that that distinction was very hard to police. I believe we will discuss that a little bit in the context of the Lion case, which I'm sure many of you are aware of in Germany. I won't talk about too many other features of the Singapore exception, but it also has a very strong contract override. But it does give capacity for publishers and other owners of content to put various throttles on the access. This was justified on technical grounds. You melt our servers if we make it completely open. But the big question is, does this exception, Singapore exception, allow the training of generative models, of LLMs in particular? And I'm not sure at all that the answer is yes. Singapore's top legal scholars argue the answer is no. We've argued strongly that the answer is no, and the copyright authorities in Singapore have not been able, do not say yes. They don't exactly say no, but they certainly don't say yes. And the arguments are burn, the three-step test, but also more interestingly, I think, and this is an argument I've been making for some time, that was also made in the famous German paper, that large language models are not extracting data. They're extracting what the German paper calls in English syntactic knowledge. They're pulling actually style. What is statistical analysis of the relationship of words to each other than an analysis of style, of expression? And that, of course, is what copyright protects, not facts. Protects expression. So I think this argument is the argument we're making, and as I said, Singapore is, when you put officials on the spot, Carolyn came to visit some of the Singapore Ministry of Law and Intellectual Property Office officials, and we asked them very directly, and they said, well, we just make the law, it needs to be interpreted. So, so that's where we are. So don't believe. When I spoke at WIPO the other day and talked about the Singapore exception, I called my Singapore officials up and said, oh, I gave this speech at WIPO, I didn't have time to talk to you about it earlier, and they said, well, actually, we really appreciated your speech because you pointed out the controls and the guardrails which are in the Singapore exception. Our problem is, the Singapore legal authorities' problem is that the tech companies are going around telling everyone, Singapore is open, you can train your AIs based in Singapore. So they themselves are not comfortable with that characterization. So we were kind of feeling, well, we haven't, I mean, by the way, we won a lot of battles in the 2021 Copyright Act. It would have, the original proposal would have probably gotten rid of our collective management organization. We were able to fend that off and so on. But we didn't win the TDM battle, that's for sure. But we were feeling like, okay, we've got into a certain situation. Then where there's uncertainty, but it's uncertainty that's creative and that's going to prevent too much action against our interests. Then in April this year was another another consultation, which said, hey, how about technical protection measures? We have a circumvention of technical protection measures. Should we allow circumvention of those measures in pursuit of this exception? Well, circumvention is legal access to protection measures is legal access. The government kept saying, you have only if you have legal access can you copy this material for training. So this seemed like a big problem. We reacted very strongly. We got great help from the IPA and other associations, and that's where the situation is, and I'm out of time. Thanks.
Thank you. Jessica, of course, being with the Borsen-Verein, if we're kind, will probably answer some questions about the Lyon case and the so-called German paper, which literally I was in Brussels and people kept saying, what do you think of the German paper? And what it meant was we all knew what they were talking about and no one had read it because no one I was speaking to spoke German. We should figure out how to get this paper around because it's really, really important and some people here may actually be able to read it. With that, Elizabeth.
Yeah, sure. And wow, the tech companies were busy, right? Because whilst they were busy with you in Singapore, at the same time, we were trying to fend them off with the copyright directive in around the same time. So they can really work on multiple fronts. So I'm going to start with a question. How many of you have heard of the EU AI Act? Put your hands up. Should I embarrass anyone? Ask, is anyone not? Well, I mean, that's pretty extraordinary, right? Given that it's only just been adopted 2 months ago, and the first bit doesn't even come into practice until February 2025. And we already, as RELX, are being asked by customers, are we complying with the AI Act? And what are we doing to comply with the AI Act? So as a piece of self-promotion, the EU has done a spectacular job. But I want to start with just a little bit of myth-busting. It is a significant piece of legislation, absolutely. And although I'm going to comment specifically on one area, there are other parts that do affect us, and we might come back to that in the discussion. But the first thing to remember is that it's actually risk-based, and that means that the majority of AI applications are not covered by the Act at all. There are a small number of applications which the EU considers so harmful, it will ban those. And those are things like social scoring, that type of thing. That ban will come in February. But the majority of work that the AI Act focuses on is things that it considers high risk. And high risk are areas like education and training, healthcare, for obvious reasons. In our area, you can see why those are high risk. There are other things so transparency comes into play when we're talking about real pure AI like chat boxes and what they call deep fakes. But the majority of applications are not actually covered by the AI Act. And the EU itself considers only about 15% of any AI is covered by the AI Act. So I think that's the first thing to remember. The second thing to remember, by the way, is that if you're putting something on the market in the EU, irrespective of where you're doing that training, the AI Act does kick in. So it's important from that perspective. So if we aren't developing high-risk AI applications, by the way, I was at a meeting with Kilian Gross, who is part of the AI office, and he said, if I had my time again, I wouldn't call it high-risk, because that gives an idea of something which, is so risky, we should be really careful. But he was just saying the impact could be important, and that's why we have called it high-risk. But yeah, so I throw out the question, why bother? There are several reasons, but one of them, I'm going to pick up your opening remarks on text and data mining. That is one reason that we need to consider the AI Act working for us. We know that generative AI providers have been using our content and that of other rights holders to train their models. I am actually not going to enter into the debate as to whether or not TDM is training, because we could be here till tomorrow. I don't know the answers, and legal authorities also don't have one answer. But I will say one thing, the EU considers it does, and has used that approach to put something in the AI Act. And I think it's really important to remember that the AI Act actually, the provisions on general purpose AI actually help us. So just going back to the relationship between copyright and the AI Act, you will recall that there are 2 exceptions for text and data mining under copyright, so-called Article 3, non-commercial, Article 4, commercial. 2 things to remember. First of all, it's only an exception to reproduction and extraction, not communication or making available. So that's a really important thing to remember. And the second thing, coming back to lawful access, it's a prerequisite. If you don't have lawful access, you may not take the content. Lawful access is a prerequisite. Once that has been cleared, then obviously the platforms, the general purpose AI models, need to check whether or not we have reserved our rights. If they have checked and we have reserved the rights, they may not mine our content. And obviously that opens the conversation to licensing and also the ability to say no. And some of the answers there were, we have the right to say no, and we should be able to say no. But a lot of attraction is around licensing and lots of conversation around licensing. So, assuming that we have reserved our rights, how do we know whether or not our content is being used? That is where the AI Act has come in to help us. And it's basically said, we recognize that there is an issue here. You don't know what has been used. So we suggest 2 things. One, we want the general purpose AI models to apply transparency so that you know what is in the system and you can see what is in the system. And that transparency has to be sufficient for you to be able to do that. And secondly, we expect that the general purpose AI providers put a copyright code in place, also explaining how they are looking and checking on those rights. So these are 2 very important provisions. However, they all depend upon rights reservation. If you do not reserve your rights, none of this applies. There are lots of ways of doing that. We know all rights reserves will not suffice, but there are lots of ways of doing so. STM itself has been very involved in setting a standard, the so-called TDM rep, which is organized under the World Wide Web Consortium, or W3C. And there are other initiatives out there to look at. But if there is one thing, and only one thing, that you remember from my intervention, it is reserve your rights. If you don't do that, nothing else applies.
Thank you so much, Elizabeth. Katrina.
Thank you. So I'm going to talk about the UK. And our starting point in the UK is that we have strong gold standard copyright law. We are not part of the EU, so the exception introduced in the Digital Single Market Directive is not part of our law, nor is the recent EU AI Act. And that gives us relative freedom at this stage about the action we take next to address AI and copyright. And we obviously have a new government, so the new Labour government that's been in power since the summer has given a clear indication, certainly in recent weeks, that it wants to act to resolve AI and copyright issues. And as a starting point, we have relayed clearly to government that we are not anti-AI. On the contrary, publishers have long innovated with AI. They embrace AI in their operations. They perform a crucial role in underpinning AI development, both as AI innovators in their own right, but also as the curators of the high-quality content that these models need, that is needed in order to create trusted and reliable AI models. But to safeguard human creativity, trusted content, and the rights of authors, creators, and publishers, it is vital that these models are developed in a legal, sustainable, and ethical manner. So that's kind of our starting point for engagement. And we welcome the approach of government, but it does come amidst an increased lobby from tech, that the way to achieve the growth that the government wants to achieve is to create or broaden an exception to copyright law for text and data mining. And this is notably the case with Google, which you may have seen prominently featuring in the recent Labour political conference, and which has put out a report calling specifically for a change in the law in the UK in this regard. And we know from our own analysis at the Publishers Association of the Books 3 dataset, we know that copyright works belonging to publishers have been used at scale without permission in the training of large language models. and that large language models have admitted to the use of this data set. And so the earlier claims that they didn't need permission of right holders to undertake these acts, they're somewhat undermined by the ask of government to create an exception, because of course you only need an exception if you would otherwise infringe. But it's worth, I'd like to just take a step back and think about exceptions for a moment, because exceptions to copyright exist for very particular purposes and established policy reasons, so preservation for archiving or something like that. But the introduction of a new exception is something that generally only happens when you have market failure, and you need a fairly major intervention to rectify it. And respectfully, we do not have market failure here. We can't say it's a nascent market anymore, but it's an infant developing market, and the appropriate mechanism, we say, for the development of that market in an ethical, legal, and sustainable manner is licensing, and on a voluntary basis. But of course, the other major consideration for us is that although we are no longer part of the EU, our neighbours over there, as we have heard, do have an exception for TDM, albeit with an option to reserve your rights, or opt out as it's sometimes referred, and that is likely to influence government in the UK in reaching a decision. It's worth noting that the UK has already consulted about whether to introduce an exception under the previous administration. And the consultation the IPO did returned a stakeholder view that this was not the route that was desired or warranted, and that resulted in the fairly dramatic abandoning of proposals to introduce an exception in the face of a collective push by creative industries. So then there was a resolution to bring rights holders and AI companies together to create a voluntary code of conduct. But this was almost entirely doomed to failure as well, because at least 2 of the platforms were already engaged in litigation, so getting them to come to the table and concede anything was of course not going to happen. And then a leading parliamentary committee in the House of Lords carried out a report into large language models with weeks of evidence from AI companies, from creative industries and legal experts, and concluded with the often quoted line that government cannot sit on its hands while large language models exploit the works of right holders for huge financial gain. But despite all that, we are here again with a new government, and we are working really hard to engage with ministers and parliamentarians and officials to reach a pragmatic solution. In terms of what will happen now, our most up-to-date understanding is that the government plans to conduct a further consultation about how it will proceed, and that we can expect that fairly imminently. And we will be representing publishers' views in the strongest possible terms as part of that conversation, and trying to work constructively to find the right solution for the UK. And what should that be? It's our view that the solution must involve right holder choice, permission, compensation, and attribution for creators, and that the key to unlocking licensing and enforcement is transparency, as Elizabeth has said, of what has been used to train the models. Transparency would be a great starting point for our government, even in the absence of an exception. So just to finish, I'd say this is a generationally important moment for the creative industries, and a real opportunity for our government to get the fundamental legal underpinnings right, to support innovation in a way that works for the economy and society, based on trustworthy, ethical, and licensed content. It may seem to be about a seemingly technical bit of copyright law, but its implications will be felt across society for many years to come.
Great. We're going to pick up on a whole bunch of these themes. I'm just taking notes and going to hand this over to you, Jessica.
Thanks very much. So I'm sitting here with my IPA hat on, and we'll take a little bit of a look at sort of the rest of the world to tell you what's going on. As IPA, we try to monitor across the globe to see what kind of legislative initiatives are popping up, what's going on, and whether and where our members need support and help in addressing those questions that they're going to be asked, consultations they may be facing. And so we network quite a lot. So one of the developments we've taken note of is quite concerning. That was in the context of the African Continental Free Trade Agreement, not necessarily where you would expect copyright discussions to come up, but there was a push for a binding regional legal instrument that could have included, or may still do so, exceptions around including TDM and AI. So we managed to put in a submission for that together with our members in the region. They also attended a hearing in that context with a very strong delegation. And the position that the IPA takes when these questions come up is that essentially the legal framework, the international legal framework, is fit for purpose. We do not need new legislation. We do not need exceptions to be introduced in order for AI to work, because with the exclusive rights that we have, licensing can work. And I think, you know, you'll recognize this from what my fellow panelists have already been saying. Another development was in the context of the Organization of Francophone African States. There was also a call for harmonization, so for international instruments in this space that, again, we view with skepticism. We don't think it's necessary. That was a call from a group of African collective management organizations in IFRO, and so we're monitoring that as well. It is important, I think, to have in mind that many African states and the African group of states in the World Intellectual Property Organization context are pushing quite strongly for exceptions in the areas of education, libraries, museums, and archives. And we are noticing the AI TDM question coming up in that forum, and that's something we're monitoring with a great deal of caution and concern. So again, we're making the point there, you know, the framework is fit for purpose. We don't need new exceptions. And what we do need is contractual freedom in order to address the needs of companies that may want to license our content for AI or similar purposes. Another one to mention is Australia. There's been a proposals paper coming out of the government there that's looking at, well, it's essentially a risk-based approach. It's looking at risks around AI and AI development and how could guardrails help to contain those risks and to mitigate them. It mentions that any data used must come from a legal source, that the aim would be to ensure proper transparency around which data or works have gone into the training of AI. But you can also tell that there's the sense that definitely innovation should not be thwarted. So we're monitoring that. We're waiting to see what our Australian member would like to do and whether we can support their efforts there. Hong Kong has also seen a recent development. There seem to be quite clear-cut plans for the introduction of an exception for the purposes of TDM. There's a consultation out to get views from stakeholders on this. And we can see there that it's the same balancing of, can we promote innovation in our region, but also how can we protect rights holders from adverse impacts. I think there's a pretty clear path towards the adoption of an exception, but the question will definitely be what kind of guardrails, what kind of protections will be in that legislation, unless they listen to us, because our submission says you don't need one. So that's where we are with that. And we did see very briefly in Korea, there was a set, actually, I think 4 different proposals for TDM exceptions, but those have meanwhile expired with the end of the legislative period. So those have been dropped for the time being, but there's also definitely interest visible there. Thank you.
Wonderful. I'm going to ask a very broad question to the panel to kick this off, and I'm going to ask you folks to answer the question how you want to answer it. It's building on something I think it's super important that Elizabeth said, which is access to the EU market for AI products is conditioned with compliance with the EU law, regardless of where you're training your AI. So I've been there's a troll who follows me on LinkedIn who always argues with me when I make this point. This is, first of all, no different from saying if I want to sell a car in the EU, I need to comply with EU exhaust standards or what have you. And for those of you who are not EU-based, like CCC, although we have a pretty big footprint here now, we tend to look at GDPR as, kind of a global baseline, because we want to do business there, and so we look at what the rules are. So it's my belief, whether, there are aspects I like about EU law, aspects I don't like about EU law on this point, but I do think it will form a global baseline, at least for anyone who wants to do business in the EU. And I'd like us to talk a little bit about that, so it's sort of a talking question. Do you agree with me that we're going to see this sort of Brussels effect around transparency, maybe around, it's not opting out of the use, but opting out of the exception, and that's a nuance, but I think it's an important one. Are we okay with this? Like, what do we think of the EU law? Like, if it does become the global norm, what do we like? What don't we like? Do we need to do more, even within the EU context? So let's focus, we're here in Germany, on the EU, which is sort of the topic du jour, a little bit more robust than some of the others. So I'm just going to turn it over, and this is us to you, because you can talk also about Germany and the Lyon case, perhaps.
Okay, sure, thank you. That's a number of questions all rolled into one. So
I told you it would be big.
I know. So the debate around the TDM exception in Germany has possibly been a little bit different from some other European countries. So we've seen quite strong resistance to accepting that the TDM exception, which was shaped sort of between 2017, 2019, and then adopted into the directive in 2019, that should apply to generative AI. So that is viewed with probably a little more skepticism in Germany than perhaps elsewhere. Certainly the position that, and this is now me speaking with my Börsenverein hat on, so the German publishers have taken the view that historically the kind of ChatGPT type applications and models were not on the radar of the legislator at the time. The TDM exception for commercial use, so Article 4, was squeezed into the directive at quite a late stage without the broadest, debate and a true, perhaps, understanding of the implications at the time. So whether or not the legislator really foresaw what that the impact of that is unclear. So the point we've been making is that any exception has to be interpreted in line with the famous three-step test of Berne. Now, this may sound like a bit of legalese, but it's actually very important. Berne says, which is an international treaty on copyright, it says exceptions can only treat certain specific cases that are clear-cut and essentially may not have a disproportionate or unacceptable impact on the rights of rights holders in the market, in practice. So we've been calling for an interpretation of this exception that would be in line with Berne. And there are big differences between having an AI that does diagnostics or that predicts protein folding, and something that then, in another step, on top of what we would view as text and data mining, goes on to generate outputs that might be in competition with the works it's been fed with. So that's a little bit about the German view on the TDM, and we are worried too that the opt-out mechanism turns essentially copyright on its head, because you should be opting in to a use, and opting out of an exception is not what we've been accustomed to, and it's not easy to do.
Yeah, it assumes that you're controlling your content, that your content's on your own site, that no one else is using it lawfully or unlawfully without your consent. It's a bit of a mess. Elizabeth.
No, I mean, I agree. And maybe we should actually not talk about opting out. because I think that does give the wrong signal. Rights reservation rather than opting out, I think. To your bigger question, I'm not going to debate whether or not the Brussels effect applies. I mean, there are treatises on what the Brussels effect means, but there is no doubt that the EU has a first mover advantage. Most of the world, except for China, have not actually done something as far-reaching and broad. And so for that, in that way, I think, yes, a little bit like GDPR, it is going to have an impact on everyone. I would actually like to add an area where I think there is a gap, and all the rights reservations in the world will mean nothing if there isn't an onus on the platforms to play their parts. And if you notice, everything gets pushed back on us. We have to do this, we have to do that. Well, what do the platforms have to do? I mean, surely they need to respect the law, right? And what are we supposed to do? Just take their word for it? Transparency is a very good way to go, but it's going to take time for that to work. And whilst I think it is extremely important, together with the copyright policy, that they have to be pinned to, I think there's something else that we can do, which is expect them to crawl responsibly. And I think this is really important. Everybody talks about, and I hear in Brussels all the time, oh, use just robot text. Use robot text and all is fine. But we know that that is not the case, right? First of all, it's really basically a traffic light. It's not controlled. If people break it, they break it. But secondly, there is no separating out the uses for which that robot text is used. So if you say no, you can say no to a whole load of things, including things you would like to have the robot text come in and do. So I think that we should be pushing back on the Commission and saying, in your requirements under your copyright policy, please put on the platforms the onus to crawl responsibly, to have a code of conduct, a set of guidelines, maybe even a registry, and that way we can see whether we can be safer in the belief that they are doing something about it. And if they're not, we then have an opportunity to go back to the Commission. But I think that it's not sufficient to reserve our rights. We need to make them liable.
Yeah, thank you. And again, I think you more eloquently stated, we should not be, when we're talking about opting out, we're not opting out of a use. This is not notice and takedown. This is, we're reserving our rights, which we shouldn't have to do under the under the digital single market, but the digital single market says we have to, so we should do it. With that said, it's not an opt-out, it's a rights reservation. Is it Peter or Katrina? Who wants to go next? Okay.
Yeah, I think I'll, first of all, opting out or reserving rights is not terribly difficult. It's terribly difficult because our content is everywhere in the world, but it's not terribly difficult to do on our own servers with our own content, and now with PDFs as well. So please do it. It took me about 15 minutes to figure out how to do it for our small content. I have to admit, I did use Claude to get some advice to write the Python script to write the metadata for the PDFs, but if you'll forgive me that, it's done. I think in the Singapore case, Singapore does not want to be a data haven. I think they're generally a price taker in international norms. So I think the situation is wait and see, vamp, try to maintain the ambiguity that the law unfortunately gives, and wait to see how the norms evolve. I think there's all to play for. We, in this group, get very fired up about the details of the three-step test and so on, but I think the court of public opinion is actually the important one, and I think we have a very good case in the sense of fairness to authors and creators, and in the sense of research integrity. So it seems to me that there's a lot more we can do in addition to fighting all these battles on the legal front. We have to be present in the court of public opinion as well.
Yeah, and Peter, I will say, because I feel like this battle is something I started fighting, and some others here started fighting 12 years ago with the text and data mining exception in the UK. We were alone then. We were alone as an industry. We are not alone anymore. We have everyone with us now, and it's kind of comforting. It gives me a little bit of confidence. Katrina.
A lot of the things I would say have already been said, so I'll be quick. But I think it's a really good question to be asking ourselves about, you know, as you said, should it, does it, and should it apply in relation to generative AI? Because it was being shaped as far back as 2017, and you're correct that, you know, while many in this industry may have been thinking about it, it was perhaps not on the radars of the legislator and of all the different stakeholders who will be so greatly impacted by it. And it seems a little bit to me like, you know, 5 years ago we've created this exception, and now with the EU AI Act we are endeavouring to kind of patch the copyright hole that we've created. And I think that kind of, what that sort of reminds me is that, you know, we shouldn't rush to legislate every time technology moves on. You know, that what we need are, you know, strong copyright law that can cope with the different evolving technologies, which, you know, is our primary position in the UK, that, you know, we have strong law, it just needs to be enforced. And I would reiterate the point I made about market failure in terms of, you know, should this be replicated elsewhere? Generally speaking, you introduce an exception where you have market failure. And, you know, the UK has this opportunity to make a decision about how it should move forward, and it may well do that in the same manner as the EU. And other countries will replicate what they see, whether it's in the EU or what the UK does. So it's our responsibility to think, you know, is this working? Could we do it better? How could we do it better? And, you know, to remember that it will be kind of replicated elsewhere. And you said, you know, opting out isn't difficult, but there are still a number of technical questions. Sorry, I'm saying opt out. I mean reservation of rights. But there are still technical questions. So, for example, if you opt out a web page, right, it's opted out, but then if someone lifts the content, like lifts the image or the text from that web page, the opt-out doesn't travel with it, and so, you know, there are still questions to be resolved about what you do in that situation. In terms of what we would like to see taken from that legislation, I mean, I think we've touched upon them. Transparency obviously is fundamental, but, you know, there are still questions around, you know, what is sufficiently detailed summary? What is that actually going to mean? How is that going to work? Can we do that better? You know, can we do that better in the UK? And also this extraterritoriality principle of, you know, you have to comply with our law wherever you trained. So those would be the takeaways.
I assume post-Brexit that the UK loves complying with EU law. Yeah, just a little factoid, which is there is a proposal in Congress that basically lifts the transparency AI language. We're on record at CCC of supporting this. I don't think it's going to advance because nothing's going to advance in the short term in Congress, but we are seeing these echoes. I want to...
Can I just pick up on one thing?
Sure,
before you open the
and then we
question
do need
on
to go to the floor.
Transparency is also important as we start ourselves to develop generative AI models, right? It's not just a defensive play. It's also how do we abide by how do we make sure we're doing the right thing if we don't know what's gone into the model? So I think it's a much bigger issue than just copyright, not saying that copyright isn't hugely important, it is, but it's actually a bigger issue than copyright.
It is, and in fact, I've loved this transparency issue because I view it as copyright adjacent. If you know what they're using, you know that you can approach them for a license. You know you can sue them if they violated the law, but it impacts on equity, it impacts on safety, and it impacts on all of those things Dr. Bashai was talking about. So it really is such a much broader issue. I'm going to... Oh,
Actually,
yeah, okay.
it impacts on how the models work and how well they work and whether other scientists can evaluate the models.
Absolutely.
Part of the
Replicability, all of these things that we care about in this room. So are there questions from the floor? I mean, I imagine there may be one or two. Wow. Oh, yeah, you're okay. There is definitely a question from the floor.
Hello, Ursula Feindor. I'm copyright lawyer in Germany. I'm one of the few who has read the German paper, all 180 pages. And I wanted to note two things. One regarding the discussed Lion case, which was not, I think, part of the panel, but which is really much discussed today, under the headline of Germany is allowing AI training under the TDM exception. I just wanted to note that this is not correct. This Lion case is a very, very small and specific case, which was not ideal to start with on the path of developing law around this question. But it is actually one of the few cases in this matter which I might even agree that we have, or that there could be made the argument that there was text and data mining, because the situation was that a non-profit organization evaluated the correlation between text and image to create a data set. And this correlation of text and image could actually even be seen as text and data mining. But then the case stopped. There was no question raised in the case whether the further use of this data set would also fall under the exception of text and data mining. So there will be new cases, or there might be new cases, which will evaluate the further use of such data sets created for scientific purpose. So I just wanted to note that this Lion case has a very small impact, hopefully, on the whole discussion, although it's very much raised right now. And I think the German paper is really helpful. So you can find a very good English summary, at least. I think the summary is about 20 pages. So you don't read through 180 legal and technical language. But this paper very much specifies the specific steps taken when AI training happens, and it differentiates between creation of a data set and then the actual steps of a training. And I think the whole discussion is often very, very, very partial, and is taking all those steps together. And I think now the question that I have, sorry for making those points, is, are we actually taking into account as much as it is necessary that there will be uses be made under the exception for scientific purposes, where we do not have this rights reservation possibility, which will then lead to a trained model or output created by AI, which cannot be tackled by existing copyright law. So I would oppose that copyright law is fit for that purpose, that a whole new model is trained, let's say, for legal purposes. And
Dr. Feinberg, thank you. I wanted to hear your take on the Lion case. The question, because we're running a little short on time, is, as I understand it, what's our concern about what's sometimes called exception washing or data washing, where a scientific organization, or nonprofit, we have a small nonprofit in the United States called OpenAI, and they use material under an exception, be it Article 3, under the UK TDM exception, under a fair use concept in the United States, and all of a sudden these small nonprofits like OpenAI find some sort of commercial use and have some commercial value, but how do you have that interplay? So I know this is something we've talked about as a panel. If one or two people want to just take on this issue, I think that would be great, and then we should have another question or two.
Oh, I think that's why the German paper is important also, because it allows us to track what is happening as the weights of a model are communicated. and as the data moves across. I think another example is we know that Llama 2 from Meta was trained on Books 3, clearly 200,000 pirated ebooks. But what is happening now is that Meta trained Llama 3 on just internet, common crawl internet data, but they used Llama 2 to do the filtering. So the model, which is outdated and everything, but is actually essential. So that training on the pirated content was actually essential to allow the filtering of the web scrapes. So it is complex.
Yeah, I think the data laundering problem is huge. And I think I was talking earlier about how I'm not the biggest fan of Article 4, though I do see, as Elizabeth described, that there are good ways of working with it. The Lion case really exposes the weakness of Article 3. And Article 3 does not have robust criteria. So Article 3, is the exception that applies for research TDM, and where there is no opt-out and no rights reservation possible, that my colleague was describing. So there are no robust criteria there to make sure it's really limited to what it's supposed to do, which is support academic research, science, and knowledge. And the Lion case shows that all it does is say, well, if there isn't a commercial entity that has privileged access to the result and control over the non-profit organization itself, then, it must be research. And so that, I think, is part of the problem with the legal framework, as well as perhaps the Lion case in itself, but yeah.
And I'm looking at you, Caroline. I would love to figure out at the end of this meeting how to get, we keep calling the German paper, and the Lion case, just some information somewhere on the STM website so people can access it and read these materials for themselves. Elizabeth.
Yeah, I've just, I agree. I mean, I think it's the Trojan horse, Article 3.
Yeah.
And whilst I am absolutely not advocating a reopening of the Copyright Directive, I carry the war wounds, as you do, from the last drafting. But I do think this is something worth asking the Commission to consider guidance on, because I don't think they realised how it could be used. The cases were very clear back in the day. Now, OpenAI, it's open, and then it's non-commercial, and then it's commercial, and there's a business model behind it. Like this was not foreseen. So I do think that is something we should be asking for guidance on.
Okay. Do we have another question? Yes, we do. Rob? Someone will get you a mic.
Thank you. Rob Johnson of Research Consulting. So it's interesting you talk about the EU. Sorry, I can stand up so you can see me a bit better. The EU kind of setting the regulatory playing field. Something we've seen in the last few months is some tech companies, so Meta, Apple, one or two others, saying they're not going to release the latest large language models in the EU because of the regulatory uncertainty. So do you see the EU continuing to set the tone, or do you actually see the potential for tech companies to say, we're going to develop products independently, we're maybe not going to sell them in the EU market because it's just too risky and costly? So it seems like there's a bit of a face-off developing between the EU and some of the big tech companies. How might that play out?
They're going to want the market. They're going to blink. This is all, look, I do government relations. It's all posturing, right? This conversation, text and data mining is now allowed anywhere in the EU under the Lion case. We really have to be super careful about the reductio ad absurdum arguments that we get every time we do this. They're going to want the market. This is not them saying, I'm not going to sell in, I don't want to insult any country. I'm not going to sell in, this tiny country here that's, the 50th largest economy in its region, right? They're going to want the EU. They're going to have to blink. And cost of compliance isn't that hard. I mean, Peter's done great groundbreaking research, I hear oh, well, we need so much data to train our AI. I'm like, well, what do you use? Well, we use the Books 3 data set. I'm like, okay, I can pick a whole lot of publishers in this room who have way more content available for license than is in the Books 3 data set. It's 200,000 books. That's a lot for some of the publishers in this room. It's not that much for all the publishers in this room. This is eminently licensable. Anyone else want to take the question?
I was just going to add that, I mean, it's the same question we have in the UK at the moment, that almost being used as a bargaining chip of, well, if you want us to come to the UK, then, you know, we need this exception, we need X, Y, and Z. But that's working on the presumption that in order to train their models, they will come here, they will set up, they will, you know, I feel like it's a little bit of a false promise, really, that training process is going to bring investment into the UK and jobs and infrastructure, and because it's a network process, right? It's going to happen on the cloud. So I think our government, you know, it's important that they sort of really look at those economic points, obviously, as well as the legal and policy ones we've discussed.
And while we're at it, the argument they make is, well, we can do all of this in the US under fair use. That is not a true statement. Can they do some of it? Is there some of these things, some of these activities that are going to be found fair use? Yeah, probably. Can everything they're doing be fair use? No, it will not be. Fair use just doesn't work that way. Every fair use case is fact specific. Every fair use case is different. One person doing the exact same thing might be fair use and another person not. So literally you could have the nonprofit OpenAI might, you know, I'm not saying it is fair use, it definitely isn't, but you know, some of the things they're doing might be fair use, but the for-profit OpenAI, the same activity might not be fair use for them. So it's way more complicated. Again, my point about they you know, these like arguments that are reduced to nothing. I've been in, everyone here has been in a meeting where someone from a large tech company said, well, we're not even making copies. And then usually there's a government who they're saying, oh, we don't make copies. And then the government person, if they know what they're talking about, said, really? How do you get the content? They're like, well, we make a copy to get the content. But once we've trained it, we haven't made a copy. We're like, so after you're done copying, you're not copying, but you are storing it because it's, you know, we hear these things all the time. Are we going to, do you want to take one more question? You want me to wrap it up? Okay, we'll do one more question. And Joris is going to choose of the 2 or 3 hands that are up who's going to get to ask that.
Thanks. Tim Vines, DataSeer. This data laundering problem that you mentioned, does that mean that most of the content that exists already has already been eaten and chewed up, and we should focus on what is being published going forward as what we want to control, or should we try and sort of get back the stuff that's already been digested?
So, okay, I don't think most, but most that's online. So if it's online, it's probably been ingested. But there's a whole lot of content that's not online, that's sitting in archives, that's sitting elsewhere. So I'd start there. I think going backwards, it's hard to unring a bell. That's what litigation is for. That's what licensing is for. There are ways to at least get compensated for what's been done, and those are, I think, are the 2 most likely scenarios. I think going forward, you should be thinking about it. And for those who know me, I'm a bit of an optimist. One of the things that causes me optimism is this very cynical notion that more and more content online is generated by AI. And if you ever played what we call in America the telephone game, AI training on AI training on AI leads to model collapse. So the AI companies are going to be coming to us as a community, not necessarily because they want to, but because they need to have stuff that's high quality, that's peer reviewed, that isn't AI generated, and they don't know what is or isn't. So, you know, there are causes for optimism. I'm being told to wrap it up. So I'm not going to let my other panelists comment on this, but before we leave, I'm sure there are plenty of people in the audience, by the way, who don't agree with me or the individual speakers on our views, and I think that's great. You know, we should have a diversity of views here on these issues. Everyone, whether you agree with me or not, you are all responsible for government relations. You are all responsible for the future of your industries. If you're on LinkedIn, if you're on social, if you're talking to people, talk about these issues, express your concerns, express the things you love about AI. There's going to be a lot of that this afternoon. Please engage, because the other side is engaging, and your voice needs to be heard. Even if I'm the other side, I'm engaging. So just please engage. Thank you very much.